In Florida, drug trafficking charges are often misunderstood. You don't have to be accused of operating a drug distribution network to face a drug trafficking charge. In fact, prosecutors do not necessarily have to prove that you sold drugs or even intended to sell them. Under Florida law, simply possessing a certain quantity of a controlled substance may be enough to trigger a drug trafficking prosecution and a mandatory prison sentence. In Florida, trafficking charges apply to people who knowingly sell, purchase, manufacture, deliver, bring into the state, or possess specified quantities of controlled substances. Possession may be actual, meaning the drugs were allegedly found on your person. It may also be constructive, meaning the drugs were found somewhere else, such as a vehicle, home, or container. And prosecutors claim you knew they were there and had control over them. Florida's trafficking laws are primarily based on the weight of the substance. This means someone may face trafficking charges even when there is little or no evidence of drug sales. For cocaine, trafficking begins at 28 grams. That amount carries a 3-year mandatory minimum prison sentence and a $50,000 fine. Higher quantities can result in mandatory minimum sentences of 7 or 15 years. Fentanyl cases carry some of the most severe penalties. Trafficking may begin at only 4 grams of fentanyl or a mixture containing fentanyl. 4 to 14 grams carries a 7-year mandatory minimum. 14 to 28 grams carries 20 years. 28 grams or more can result in a 25-year mandatory minimum and a $500,000 fine. For heroin and certain other opioids, trafficking also begins at 4 grams. Depending on the weight, the mandatory minimum sentence may range from 3 years to 25 years. Prescription medication can also result in trafficking charges. Oxycodone trafficking begins at 7 grams, while trafficking in methamphetamine or amphetamine begins at 14 grams. Cannabis trafficking generally involves more than 25 pounds of cannabis, or at least 300 plants. Another important issue is conspiracy. A person may be prosecuted for conspiring to traffic drugs when the state claims that 2 or more people agreed to commit the offense. Prosecutors may pursue a conspiracy charge even when the drugs were never actually delivered or possessed. These cases frequently arise from undercover investigations, confidential informants, wiretaps, surveillance, cell phone evidence, controlled purchases, and search warrants. But a trafficking charge is not the same as a conviction. Potential defenses may involve an illegal traffic stop, an unlawful search, a defective warrant, lack of knowledge, lack of possession, unreliable informant testimony, laboratory errors, inaccurate weight calculations, chain of custody problems, entrapment, or other constitutional violations. The weight of the substance can be especially important. Prosecutors may rely on the total weight of a mixture, not merely the amount of the controlled drug contained within it, to reach the trafficking threshold. Because these offenses carry mandatory minimum sentences, judges may have very limited sentencing discretion after a conviction. That makes it critical to investigate the evidence and identify possible defenses as early as possible. If you have been arrested or charged with drug trafficking in Tampa or anywhere in Hillsborough County, contact Hunt Law at 813-787-4849 for a free and confidential case consultation.